Recording in progress.
Welcome everybody to 2 o'clock. First, an apology. We were given the last Friday to give a response from National Treasury on the submission made at the public hearing, but unfortunately they were briefing the provinces throughout last week, and they got the DG and others contacting us to say that could we please postpone? And we also got a letter from the minister. Obviously, it's Parliament that decides the program, but we have to take into account the department's many commitments, and we thought, although we're not happy with the revisions on 3 working days, 4 working days, we let it be. So here we are. Secondly, to inform the stakeholders here from civil society, welcome in particular to you, that we have applied to the NCOP chairperson for an extension of the 8-week cycle within which both of the processes that come to the NCOP. That's our constitution and legislation and rules. We have submitted a letter after a meeting with our committee to say we can't finish the full 8-week cycle as on the 22nd of March, and we can't complete the other deliverables as well. So we have it that the letter they all as well. We get the extension, which I think we will, and so we'll carry this bill all the way to 8. Having said that, welcome to the Treasury officials here. Are there any apologies for the letter?
No, I do not receive any apology. Thanks.
Okay, you identify the people who are here who made submissions at the public hearings, right? Okay. So over there in Treasury, who's leading your team?
Good afternoon, Chair, and the honorable members of the committee. My name is William Matebla, Chair, and thank you very much for advocating. With me, Chair, in the boardroom is 2 advocates, Van Spoor as well as Shirley Misa, so they are with me here. And I'm just going to do the introduction of what has happened since we met on the 6th February. Okay, Transport will then take the committee through the rest of the presentation. We don't have a normal presentation, but we're using the report that we circulated. And I must just say that over and above the 27 written comments that we received, the Gauteng as well, gave us their comments, to which we were requested to respond. And by the way, we did in Gauteng on the 29th February, and we responded last week Friday on the 8th. The Western Cape as well, we were in the Western Cape last Friday in the public participation session, and they also submitted their comments, and we still need to do those comments tomorrow because we need to appear for the committee in the provincial legislature on Monday. So that is shared by way of background. And then in the report, we can share the report. Please, sorry, Chair, we're trying to have the report shared. Apologies for that. Trying to have the report shared.
Yes. Okay, thank you. In the meanwhile, agenda provides. Okay. Can I just finish this process? I should have said this at outset. Sorry, you know what? What we're going to do here is hear that session. Then we'll ask stakeholders to reply. Then we will come in and take up questions in both National Treasury and civil society participants. Okay, that's the agenda. Okay, so right.
Thank you very much, Chair. So what we did, Chair, after the 6th of February, as you know, that we briefed the NCOP, and then we briefed all the other provincial legislatures, as you can see, on the dates indicated in the report, except for KZN. I think KZN did not, of course, I think they did their own. So we did not go to KZN. So that's what happened. And then just below that, in the upper part of that first table, the second table, the next one, just indicates now the public participation session where we went to physical. You can clearly see that at this stage, they had 5 at least of their participation sessions.
We can save time. You've reported what has happened, and we can look at that.
That's fine. And then I'll hand over to advocates for us to take the comments. Thank you very much.
Thank you.
Chairperson and committee members and stakeholders in the meeting. The report that we picked up on the main issues that from the comments that we received. We did submit a comment matrix in which we responded to the bulk of the submissions. There's one submission that we were not able to complete, and that's of the Western Cape. The source was also submission, but we did attend to the constitutional issues and general comment. And then as a national foundation, we use the summary to prepare our comments.
Somebody seems to be, just one second. Somebody seems to be interfering. I don't know if it's on your side, Treasury, or who, but there's crisscrossing of conversation or noises. Can whoever the responsible please stop that? I think it's gone quiet. Thank you. Okay, go right ahead.
Thank you very much. The first matter that we pick up on, which is, I think, in many submissions, that's the one dealing with constitutional concerns. And obviously, we appreciate all the comments received and the spirit in which they were made. But we do believe that the bill would meet constitutional muster. But there are a few aspects that we propose amendments. Some of them are in this document that we will highlight. Now, the first issue pertaining to constitutional institutions relate to Chapter 4, which
Colleagues, is it just me or
no, we all lost it.
Yeah. I think there's a connectivity problem on your side.
They locked out. What's going on?
I don't know. I no IT than you do. What's going on in Kuala? Can you ring them and find out? The rest of us, yeah, we can hear you now. Go ahead.
Apologies, Chair. We have even had Sita here to come and assist us earlier. We do have problems on our side. We hope it will not repeat. And I just want to share the document with continue. Then, on the constitutional concerns, is the first standalone reading of section 217, which ignores 217.2, is not only a disservice to statutory interpretation, but also ignores the founding values of the Constitution. I'm not going to deal with everything in this because we do write a lot about chapter 4 in this provision, in this part of the document. Now, an important point that was raised by commentators that I think when we were before the National Assembly, they said, well, this is not a framework, we say too little. And I think now most of the comments is that the framework is too tight and we regulate too much. Now we do submit that it's within the authority of Parliament to determine how tight or loose the framework must be. And we will also reference opinion from Advocate Stephen Butler, who's a senior counsel at the time, he left the bar now, that he furnished the National Treasury when we were busy with the bill during the NETCAT process, which said it's a choice that Parliament must make, whether it should be very tight or it should be loose, and what is allowed by organs of state. And then other important point that we want to make is that the authority to determine or to implement procurement policies remains with procuring institutions or organs of state, but they must adhere to the framework in this chapter and also the regulations that the Minister is required to make. And then another important matter that also relates to the Agribusiness Constitutional Court judgment is that the provisions regarding pre-qualification and also subcontracting as a conditional contract, which are included in Chapter 4, in our view, is not simply a copy and paste of what we had in the 2017 regulations, because we adapted it for the bill, and then the particular judgment stated that happily both the first judgment and this judgment, and indeed the Minister understand impugned regulations to do what's envisaged in section 2172 of the Constitution. The main problem is that the Minister didn't have authority in terms of the Triple PFA Act to do so, which we now submit and we do in Chapter 4. So the regulations do now, the regulations Chapter 4 do provide for pre-qualification and also subcontracting. Then I think I'm just going to refer to another statement from the court judgment, which said it must be emphasized that the scheme of 217 of the Constitution, as that the section authorized the state to, in circumstances, to exclude from the award of contracts persons who did not suffer unfair discrimination under apartheid in favor of those who were discriminated against. And that this is an exclusion that constitutes an effective tool in the hands of the state to redress the injustices of the past. So in view thereof, we submit that the provision for set-asides, which is also in Chapter 4, which is the first main provision dealing with preferential procurement, that is permitted if you read the court judgment. I'm going to proceed and not deal with everything as indicated. Another point that we want to make is that the process for making regulations is much more rigorous than what was in place in terms of, so that I see my laptop say that internet is unstable, but I'll proceed, hopefully you can hear me, is that the process is much more rigorous, and there's a requirement that the Minister must publish the regulations for comment, and also there's a requirement to prepare a statement pertaining to the draft regulations to assist the public to comment on the regulations. And then there's also a requirement that the regulations must be submitted to Parliament for scrutiny. I want to proceed with clause 18, where there was some concerns about whether we're not undermining competition. But in our view, it's not that there's sufficient checks and balances in that clause of the bill. And I think just to reiterate that although apartheid was dismantled many years ago, there's still a need to eradicate its socioeconomic legacy and advance policies that build an inclusive economy and promote social unity. Then the chapter 4 that we propose, that's proposed in the bill, goes further than a triple PFA. Sorry, Chairperson, I don't know if you can still hear me.
We can hear you,
But
but
we've lost the prediction.
But in any case, we have it on our computers, so try to put it back on, but don't hold yourself back because you've submitted it as late as it came, but we have it.
Okay. Thank you, Chairperson. I'll just maybe then read from the document.
But do try to put it on the screen with your staff. Yeah. Without holding up the process, is what I mean.
Yeah, it's okay. So okay. I think it's back now, Chairperson.
Yeah, page 5.
Yeah, what we have in chapter 5 goes further what we had in the triple PFA. It does not merely provide for preference point systems, but other measures to ensure meaningful empowerment. Then proceed to the next page that deals with the parameters of preference. That we, in this regard, I think it would be important to look at provisions that address negotiations with bidders, which is envisaged that would include negotiations for a fair market price to prevent government paying exorbitant prices for contracts awarded. So that's something that we do believe that should be dealt with in the regulations. And I think the important point is that we want to reiterate that 217(1) and all the subsections 2 and 3, should be read together and they can coexist as required by the Constitution. And that tenders must still be evaluated in a manner that gives effect to the purpose of 217 in respect of fairness, equity, transparency, competitiveness, and cost effectiveness. And then I'm not going to deal with the issue of equitable. It's outlined there in the text. But I think that if you simply just look at the ordinary meaning of equitable, I do assist in interpreting both the Constitution and the bill, is that it means accounting for varied circumstances and allocating resources and opportunities each person needs to receive an equal outcome. Then there's some commentators that refer to the wording of 2172 of the Constitution, maintaining that it's not mandatory. I again want to refer to the opinion from senior counsel that confirmed indeed 2172 is not mandatory, which say organs of states may implement policies to give preference. But the opinion continued to say it's a choice of Parliament to make it mandatory. So it would be within would be constitutional to do so. And that's what we propose in the bill, that the implementation of preferential procurement policies by institutions is that would be compulsory. Then there's comments on the clause in chapter 4 that deals with local production and content. Now, this provision is meant to deal with vulnerable categories such as local manufacturing base of the country, and the design of clause 20 is to deal with that. And I think an important provision is that currently, or these provisions, it's not necessarily published for comment, and there would now be a requirement for prior to designation that they should be gazetting by the minister. And then it's important there's considerations that the minister must have before making a designation, which is listed there, which are quite important for making the decision. And again, I think in the case of clause 20, we do submit that we think it has the necessary checks and balances to deal with designation. In clause 21 of the bill provides that if section 17, which is set aside 18 pre-qualification and 19 subcontracting as a condition and 20 designation of local, those provisions are not applicable, preferences must be allocated as prescribed, which means that the minister must make regulations. Now, it proposed that the regulation-making power be circumscribed in more detail to ensure that it's not too wide. And amendments to this will be proposed for consideration at the next SECOF meeting on the bill. We were not able to prepare something on this particular provision. And I would also request that we discuss it with Advocate Jenkins once we have a draft of the amendments. Then the next constitutional issue raised is about, which I think we have touched on earlier, is about the 5 principles in 217 of the Constitution. Now, encapsulating these principles in the bill through balancing them or choosing one over the other is not feasible, neither appropriate in our view. Now, importantly, the principles in 217.1 must also be adhered to together with the other provisions of the Constitution, which includes the other provisions of 217, and then also section 195.1 and 216 of the Constitution. 195.1b is about the transparent use or the proper use of state resources, and 216 deals with the establishment of a national treasury and the role to determine uniform treasury norms and standards related to, amongst other, expenditure control. Now, these provisions we do refer to in the preamble and the objects clause, and if you read the bill together with the regulations that obviously must still come, it will direct procuring institutions on how to give effect to these principles in their procurement systems, which includes their policies. Now, a comment from one of the commentators that preferential treatment as required in 217 argues that the premise that there's a conflict between 217.1 and 2 and 3. Now, our view, again, these provisions coexist and it must be implemented in the procurement system of each procuring institution within the framework of what the bill will say. Then, about the scope of the bill, maybe one or more comments that we receive is that the bill goes beyond 217.3. That's a section that deals with requiring national legislation on preferential procurement. Now, the comment was that we are actually not supposed to regulate or propose to regulate matters in 217.1. Now, national legislation like the PFMA and the FMA is now a view within Parliament's legislative authority, and 216.1 of the Constitution requires national legislation to prescribe measures to ensure transparency and expenditure control in each sphere of government by introducing, among others, uniform treasury norms, which in our opinion includes procurement. So chapter 4 is not, we deals with preferential procurement, is not the only matter that should be regulated or may be regulated. It could be all the other matters that's contained in the bill. So regarding cooperative governance, to repeat, I think this is a concern raised about whether we interfere with the powers of provinces and local government. And I'm not going to repeat the section I just read, which is 216.1.2. And there's also a requirement in 216.2 that National Treasury must enforce those treasury norms in government. Sorry, I lost my place. Therefore, the legislative and executive powers of provincial and local government, our view, are not observed by the bill. The minister also may make regulations currently under the PFMA that's applicable to provincial institutions and under the MFMA that's applicable to municipalities. And just by comparison, also Treasury is currently empowered by the PFMA to issue instructions that apply to provincial institutions. And there's authority for provincial institutions, treasuries to issue instructions applicable to their provinces. Now, according to Section 156 of the Constitution, the legislative authority of the local sphere of government is vested in the municipal council. The bill, in our view, do not undermine or amend the independence or the constitutional authority that's vested in the municipal council, and it seeks to regulate procurement in a uniform manner in the public sector. Now, the regulation of local government in the bill is comparable to the current MFMA, which includes the entire chapter on supply chain management. And there's also a set of regulations dealing with supply chain management. And currently, the triple PFA is also applicable to local government. So I think the difference would be now that when it comes to procurement, you would have a single bill that deals with national, provincial, and the local spheres of government. And once again, we submit it's not precluded to have a single statute to deal with this. I think an important clause in the bill is that we also provide, the bill provides in clause 8, that the procuring institution must implement procurement institutes within the framework prescribed by regulation in terms of 25, and that this also includes the procurement policy. And so that would be for the municipality to implement the system and to develop a policy for that system. Then I think another point to raise in relation to this that is clause 21. That there could be, there was a separate comment that was raised about municipalities' ability to ensure to address matters in line with the local content. Now, sorry, so it may not be the point now, apologies, Chair. Then we specifically in the bill provides that the Minister of Finance must consult all relevant ministers on proposed amendments. And what we're proposing that we specifically provide, that's an amendment we're proposing, that the Minister must consult organised local government, which is currently SALGA. And then these are other amendments we thought that was identified by commentators that might be problematic. And if you consider Section 216 of the Constitution, is that we propose that the authority for the Procurement Office, the national one, and provincial treasuries to issue instructions applicable to municipalities be replaced by circulars, which the municipality may decide to adopt or not. So that's one proposal. And then they're also proposing that the enforcement function of prevention, because in our considering 2162 of the Constitution, obviously outside interventions that's regulated by other provisions in the Constitution. So this last paragraph is a reiteration now, the independence of the Public Procurement Office. Now, once again, relying on Section 2162 of the Constitution, the role of Treasury to enforce compliance with uniform norms and standards, which include procurement rules, that could be determined in both primary and subordinate legislation. Our point is that placing the Public Procurement Office in National Treasury is actually not, it's not just only according with 2162, it's required that it should be National Treasury performing that function. Obviously, you can argue, but if it's located within National Treasury, we submit it. comply with 216 of the Constitution. And it wouldn't be a body that's distinct from National Treasury. And an important consideration as the bill provides for regional powers for the Procurement Office, and it will not be dependent on delegations from the Minister of Finance or the Director General of National Treasury, which provides for separation from the other functions of National Treasury and gives some level of, I don't want to call it independence, maybe separation is the right word. Now, if important consideration also is that the role of the Procurement Office is to perform functions regarding government requirements, which could not be provided in-house. So it's of the private sector. It does not regulate procurement by the private sector for their own needs. So I think we submit that the comments about independence is not something that's relevant for a body that exercise these powers, and then also if it's supported by 262 of the Constitution. And some commentators also inquired about, and just to clarify, that the appointment of the staff and the head of the Public Procurement Office, they will be appointed in terms of the Public Service Act and the relevant provisions. Then the function.
MP, you've been cutting off every now and then. I've let it pass because we have the text on the screen and on our computers, but now you've gone dead. Hello? Can you hear us? We can't hear you. Oh dear. Oh dear. In Kululeko, can you help?
Hi, Chair.
Can you help?
The problem here is that Microsoft is down, so it's affecting quite a number of apps that are linked to Microsoft.
Chair, I think we are back.
Yeah, you're back now, yeah. Okay.
Good.
So is the document still shared? I can't.
Yeah, it's on the screen.
Yeah, to come to functions of the Public Procurement Office and Provincial Treasuries, I think the comments we receive is that it's not always clear exactly what the functions. And I think the first point we can make that there's overlap, not the overlap, but because the Procurement Office would operate nationally mostly, and Provincial Treasuries have particular functions in provinces, and that is set out in the clauses 5 and 6 of the bill, and that some of the functions is exactly the same because of the particular role that have to be played. Now, sorry to go down on the screen. Then I think the point to be made is that Provincial Treasuries obviously will operate or function within a provincial administration. If you look at the current functions of the Procurement Office, it's similar to what is currently in the PFMA as well as the MFMA. So there's no real new powers. Well, there's some maybe new, but in general, it's aligned to those powers. Then, as to clause 6, which refer to provincial treasuries, they already have an enforcement role in terms of the PFMA. Then also to emphasize, because there was also raised the issue about instructions that are issued either by the Procurement Office or Provincial Treasuries. We do believe it's more clearly delineated if you compare it currently with the PFMA, because the PFMA, so anything that you can make a regulation on, you can also make an instruction. So we have a distinction between what the Minister may make regulations and then specifically deal with what the Procurement Office may make instructions on. And it's very specifically provided for it, and then the only general provision is that it could be issued for the effective implementation of the Act. And then there's a similar power for provincial treasuries to do so within the province. But as advised, we propose that these instructions, either issued by the Procurement Office or the Treasuries, may not or should not apply to municipalities, and that it should rather take the form of a circular that municipalities have the choice to accept.
Hello, we can't hear you again, National Treasury. In Kululeko, is this a problem with Microsoft or is it their network in the National Treasury Office?
Chair, even network is affected even on my side. Esther had the same problem as well. So it's affecting quite a number of issues.
So what I'm trying to find out is tomorrow we got public hearings, right? If they move to some other place, some other department, or found a room in a hotel, or one of these meeting rooms, because we can't carry on like this. I mean, we are under a lot of pressure time-wise. And now, so can you sort all this out with Treasury after this meeting? If it's a software problem or whatever it is, then it's a generic one. It doesn't matter where you are based. But if it's a network issue about connectivity, presumably, if they move to some other place, they'll be able to connect more easily with us. Or am I wrong? Anyway, that's not for discussion here. But now this is immensely frustrating, really. We're not blaming anybody. But now, look, we're stuck. And there's the stakeholders of civil society here. Hello? Oh, man.
Can hear you, Chair.
Right, you're back. Listen, can I ask a question? If you took this off the screen and you took your visual side off and merely engaged us through audio, would that help in any way?
Chairperson, I really switched off the audio after video.
All right, fine.
Apparently, it's a problem with Outlook, which is it's general, it's not just Treasury.
Oh, so because you can't move to some other place tomorrow morning when you come to us again, not you or your officials, eh? Wherever you sit, whether it's here or where we are in Cape Town, it'll make no difference, is what you're saying.
Yeah, that's my understanding.
All right, fine. Let's deal with that outside the meeting. Yeah, let's not detain ourselves. Focus on the issues, please. We're worried we're losing you.
Chairperson, then on the decision making, the first, I think the most important revision is clause 7, which makes it clear that decision making of procurement based in the accounting officer or accounting authority of the institution, and it accords with the financial responsibilities of accounting officers and authorities under the PFMA and the MFMA. And then, which I indicated earlier, accounting officers and authorities must implement the procurement system, and must also implement procurement policy. So it will not be determined by the Public Procurement Office, and it will also not be determined by the provincial treasuries. It would be a role that will remain with the accounting officer or accounting authority. Just to explain, the accounting officer is used in relation to departments and institutions and also municipalities, while accounting authorities concept used for public entities in the PFMA, which is mostly the board of the entities that has that role. And then also, we do believe that the alignment between the PFMA and the MFMA on the one hand and the bill on the other hand are providing for this particular role of accounting officers in making procurement by the proposed amendments to the PFMA and MFMA in the schedule to the bill. Yeah, I did explain the terminology used. Then on the issue of integrity, transparency, accountability, fairness, and anti-corruption measures, once again, as indicated earlier, the bill is premised on section 195, 216, and 217 of the Constitution. Now, in various ways, form part of the provisions of the bill. The issues relating to the fighting corruption and anti-corruption measures need collaborations with relevant government institutions and law enforcement agencies. The bill, with all its provisions on integrity for the procurement system and anti-corruption measures and transparency, may not be the only instrument through which to combat corruption. Now, regarding the proposed anti-corruption agency in the recommendations of Judge Zondo, our view is that such an agency is best placed within the departments of that's in the justice cluster. Now, as to various transparency measures and anti-corruption measures, we do believe the bill, there's many provisions that deals with this. And one of them would be the codes of conduct for everyone involved in procurement, and contraventions of these constitute misconduct and other appropriate steps for people that are not officials. The bill also provides for the prohibition of undue influence in procurement process, declarations of interest for people involved in procurement, and also the automatic exclusion of certain persons from submitting bids. And then there's also the provision of dealing with the bargain.
We lost you again, Mr. Matebula and MP. Let's score.
Mbonelo baby.
Like I say, I'm like I'm so big.
Yeah, mama.
What you eat it looks like a ball.
It looks like a ball.
Those sounds, Chair.
Yeah.
Somebody's mic, baby.
I'm more worried about Treasury right now. But I agree with you. MP, you lost again, man. I'm sorry, but you are.
Are we back, Chairperson?
Yeah, you're back now.
For how long? So the provisions on debarment that applies to bidders and suppliers, and also directors and members and etc. of those bidders and suppliers, is also an important protection. And then what I mentioned is there's a protection for officials where people in positions of authority give them directions that's inconsistent with the Act, to protect them against. And there's also provisions relating to offences to people that give false and misleading information or connives or colludes to commit corrupt or fraudulent actions. So we do believe there's a lot of anti-corruption measures in the bill, and to the extent that it relates to procurement. Then, as to specific transparency provisions, there's also a number of provisions. The object clause emphasise that
You lost again.
Hi, Chair, so long. There's a hand from Mr. Ryder.
Yes, Mr. Ryder.
Mr. Chair, I think you're expecting what I'm about to say. This really can't go on. I mean, as much as I really am committed to my duties with the Finance Select Committee on Finance, you know, this presentation hit our inbox 2 hours before the meeting. I was busy with other things. My diary is full. I try and give South Africa value for for its money, and so I book my days out. Now, we haven't prepared properly for this meeting. The content of the presentation indicates that, you know, they don't feel very strongly about what they're presenting because it's not a very compelling presentation. And we're sitting with these internet challenges. And Chair, I understand that that might be impacting the delivery of the presentation and how MPs feeling about it, because I'm sure it's frustrating for her as it is for us. And it appears to be a general issue. I have placed an article on our chat group on WhatsApp, Chairperson, but it does say that there are massive internet problems in South Africa. I'm fairly sure that you know, the contents of this presentation have not been digested properly by people, and I'm wondering if it's even worth continuing with this meeting, Chair.
All right, you could avoid the long speech and all that. I mean, what you're saying about yourself will apply to all of us. Look, I was teetering towards that, but I thought that, you know, I hadn't realized the fundamental problem. I thought it's more a problem with Treasury and then Nkululeko intervened, but I also am immensely frustrated. So I think we should draw this meeting to a close. I'm more worried. You see, the reason there's a committee meeting, I would have said this half an hour ago, but because, you know, I see your comment, it's uncalled for. When you're chairing, you have to clarify, because it's not about you, Dennis. Don't individualize it. It's addressing mostly the civil society stakeholders here, and for those few people who care to watch us in the public, who don't know the things you and I do. So because the stakeholders are here and they've given up their time, I've been hesitant to do it. But we reach a stage now where if the majority agrees, I think we should stop this meeting and find another time. Now, people shouldn't complain and whinge and whine. We'll have to do it outside of the normal Tuesdays, Wednesdays, and Thursdays. So we'll have to do that. And nobody is immune to the election campaign. All of us are involved. So it's not one person or one party. Having said that, the point is there's a call for the closure of this meeting. Is there agreement on that? Okay, how many people are opposed to closing this meeting down for now?
I agree to that closing, Chair.
Yeah, I know, I agree.
I also agree. I also agree, Chairperson, because
so
we
didn't a long speech. Yeah, we
There's
agree.
not
Now the point
conclusive.
is, can you help us, Dennis, because you seem more clued up, and anybody who's technologically clued up, is this something that's peripheral, I mean temporary, or is it likely to continue? Anything you can't say at the moment. How is it that we're able to talk, but National Treasury can't? I don't follow. Dennis, can you explain to us?
Chairperson,
We're all functioning fine. Yes, Linda?
Chairperson, I just arrived now at my house in Acacia Park, driving from Parliament. By the time when I was in Parliament, I was there at the IT site, and they're saying the network in South Africa is a problem.
Oh, so we don't know how long it'll be, because I'm worried about tomorrow morning's meeting.
Okay,
we can't discuss those issues here. Nobody is IT savvy enough to tell. So can we draw this meeting to a close? In Nkululeko, we'll have to renegotiate this. But we have to save our public hearings for tomorrow. Okay, Dan, anything else? Nope. My apologies to the stakeholders on behalf of Microsoft or whoever it is that's responsible for this. And we look forward to meeting again. We will set the time for next week, one of the days, probably in the evenings, because we don't have much other choice. Thank you. Bye.